Hello, good morning, and a warm welcome to everyone. On behalf of THAKUR RAMNARAYAN College of Law, I, Devina David, would like to thank you all for joining us on our today's webinar, which is scheduled on Art of Mooting. We really appreciate you all for taking out the time and being here with us today. Now, I would like to introduce our esteemed guest speaker for the day, Advocate Yashraj Samant, sir. Mr. Yashraj Samant, sir, is a practicing advocate specializing in dispute resolution, international arbitration, and mediation. Sir is the founding General Secretary of the Center for Arbitration and Research, Eminelli, Mumbai, an attendee of the prestigious Cologne Academy on the International Commercial Arbitration, Germany. Sir has also been mentoring students and law schools both nationally and internationally for various ADR and mooting competitions. Advocate Yashraj Samant sir is a frequent judge and an assessor at various international and national moots, negotiations, and mediation competitions. Sir has himself been an avid mooter during his law school days, having represented his university at the Wilhelm C. Wills International Commercial Arbitration Moot, Vienna, Stetson International Environmental Law Moot Court Competitions, India Rounds, and many more. Sir was also the second best mediator at Lex Infinitum International Negotiation and Mediation Competition, and the third best mediator at CDRC Mediation Competition, Vienna, Austria. Sir is a national level badminton player and a sports enthusiast. He has worked extensively in the field of sports and gaming laws. Advocate Yashraj Samant sir is an alum of the renowned Maharashtra National Law University, Mumbai. Sir, we are honored to have you along with us today. Before we start, I would like to inform all the attendees that this session is going to be an interactive session. So the participants can ask their queries by either typing it down in the chat box, or at the right time, they can ask Sir by switching on their camera and having a one-on-one session with Sir. Participants are also requested to kindly keep their mics on mute so that there is no disturbance caused during the entire session. And also, any misbehavior would lead to the removal of that particular attendee from the course of the entire session. Now, we would love to hear from you, sir. The floor is all yours. Thank you.
Thank you so much, Devina, for such a wonderful introduction. So, hi, good morning, everyone. My name is Yashraj, like Devina said, and I'm here to talk about something which I personally hold very dearly, and I believe that most of the students across law schools in India do not understand the real value of. So, we are talking about today mooting, which is one thing which I have felt has always helped me immensely in ways which are not so obvious. So before we start, I have been told that there is a mix of a few first timers who are not really that experienced in mooting, a few, some frequent ones in mooting, etc., and a good mix of people who are habitual to mooting. So I'll do my best to make sure that this remains a session which is informative for everyone, whether you are a first timer or you're an experienced or a seasoned mooter. And I will also do my best to make it as interactive as possible. Although technology has taken us this far that we are connected even in such times of pandemic, but sadly enough, there is a lack of interaction over such platforms, but I'll do my best. So whatever questions you might have, which you feel like asking at any given time, you may put them down. I'd request the team of TRCL to please help me out with that and just direct questions at me. And if you also have a questions, I think so. If you prefer to ask them at the end of the session, then I can definitely take them up as well. So to start with, today we are going to be discussing a lot about fundamentals of mooting. Obviously, the theme is the art of mooting, but it has a little more to it. In my lifetime, only people, those who have said that they have not learned anything from moot, are the people who have actually never done a moot. That is in my experience, because every moot to me has taught me something different, has taught me something which I have been able to inculcate in my practice now. And obviously, I'm certain that I can build upon later. So, in today's session, there'll be a few things that we are going to discuss about. I won't be going into excessive details because of the lack of time, but we'll definitely touch upon all the basic tenets of starting from right, what is a moot, and going all the way to oral advocacy skills, which I believe are very important and would definitely help you out a lot. So, if I can just ask Ankush to maybe, I've prepared a little PowerPoint presentation which should help uh, throughout the entire lecture to keep you guys engaged. If I can request Ankush to please put that up online, Ankush. Sure. While Ankush puts that up, I think so it's good to mention a few things. So, interestingly, everybody here has or probably will hear of something called a moot in, during the course of your law school, your law college, or maybe you've also heard of it before getting into one during your school days, so to say. But what I wanted to talk about is just understand for our purposes what exactly is a moot, so that all of us are we have a working understanding of where we are coming from. So, although the word moot itself means to deliberate on something, to discuss an idea, but in terms of our usage, the legal fraternity's usage, moot refers to a set of mock proceedings. So, ideally, these are proceedings which are taking place, legal proceedings or judicial proceedings, which are taking place or having been recreated. Some people also use the term simulated, but I prefer not to use it. Now, if there is a proceeding, that means it has to have certain essential features, right? Only then it would become a proceeding per se. So, to start that off in a moot court, you need to have something which you are discussing, right? So, that is what is called a set of facts. So, you're given a set of facts, you're given some laws, and then you identify what your issues are, you seek relief from the court, and you go ahead with your submissions. Now, obviously, when you are discussing a set of facts, it can't be a monologue per se. So, you would rather have to have multiple parties going ahead, and you can have two parties at the time, which is something which we have all grown up watching also on the television, that you have two parties who are battling it out in the court, or you might also have at times three parties. There are cases, and I'll explain that in a bit, but usually there are at least two parties in any given moot court or any moot proceeding, so to say. Ankush, can you just flip over to the next slide, please? Perfect. Now, when you have two parties, when you have a set of facts, what else do you require? You need an adjudicator of sorts. So, the adjudicator would be a judge. The judge is also responsible for marking you on the basis of your submissions, be it written or oral. And that judge will also take into account other factors if it's in a setting such as maybe, say, the regular trial advocacy moots, then you would have something of a trial court judge ideally sitting there in the capacity of one or representing one. Or if you have an arbitration, then you would have the judge or the assessor in the form of an arbitrator or a tribunal. So there are different things which we'll definitely cover in due course. And what ideally are you doing through your submissions? Never lose track of the fact that what you're doing at the end of the day in any moot court is that you're seeking relief. Now, that is very identical to what you do even in real life. So you go to the court to seek relief, you identify a legal injury which has been caused to you, and you go to the court asking for a particular relief, be it in whichever form as it may. And you do the same thing in the moot. Obviously, in the moot, there is no determination made because ideally you are just arguing a hypothetical case, so there can be no real reliefs. But still, the idea is that in order to seek some relief, you make some submissions in front of a judge, and there are two competing parties, so they both put their interests forward, and you do this on a given set of facts or problems applying to law. And that's a moot court for you in a nutshell. Now, if we switch over to the next slide, Ankush, I believe all of you must have already heard of these things somewhere here or there, maybe from your friends, maybe from your teachers, your moot court committees, or even from your juniors at times. But these are things which will definitely be used a lot in today's lecture and are commonplace in all the moot competitions and moot propositions which you will find. So you would find something called a moot problem, which is ideally the set of facts on which the entire premise is based for you to proceed with your argument. So you have your moot problem, you have Sometimes they call it a compromise, sometimes they call it a proposition or a record. It's just a matter of terminology. It does not matter. It all entails the same thing. There are certain facts and they are given these names. Now, what do you do with this? You make your submissions in the written format in the form of something called a memorandum, or at times they are called written submissions, or at times they're also called. I think someone has their microphone on. If I could please request you just switch that off. Thank you. And then you would have your parties. Now, the parties are also called by different names. So, just like in real court proceedings, you could have a petition. So, whosoever files a petition is called a petitioner. Whosoever files an application is called an applicant. Or you may be a claimant if it's an arbitration, or you may be an appellant if it's an appeal to the higher court, or you may be a plaintiff, or you may be the prosecution. So all of it entails someone who brings about the case in the first place. So the person who brings a claim, or the person who puts up a case in terms of, say, a prosecution, or maybe a petitioner who brings about a petition claiming for certain relief, certain rights. And on the other side, you have either your respondents, which is a common term again, because someone who responds to these particular claims is a respondent, and it can alternatively be called a defense. It can alternatively be called defense in cases of trial advocacy or criminal law moots. And with respect to now the lawyers themselves, those who argue it out, they can be called counsels or agents in certain international moots. And then this is something which you all have probably grown up watching on television, in all your movies, and even heard everywhere. Your Lordship, Your Honor, Your Excellency, Miss President, Mr. President. All of these are terms which you use to respectfully refer to the honorable court, or in cases it could be the tribunal, or anyone who's basically there to adjudicate upon your particular case, right? So these are common terminologies which once you keep in your mind that these are just simple five things which you can always remember by, it'll be much easier. Now, if you switch over to the next slide, and that is the most important part why I'm here today. So, what exactly are we going to discuss today? Now, I'm not here to make a case in front of you as to no, you should always move. What I would rather do is I would help you identify that one thing, that one little bit that you have always felt you could improve, and I would help you identify that in mooting somewhere. So what I mean to say by that is, if you see, all of us have, certain things which we are really afraid of. Be it sometimes it's the fear of public speaking, sometimes it's the fear of being judged by someone in front of other people, or maybe our peers, or other things. What I would help you today is for each of you to identify that fear, and I would help you locate that in the entire process of mooting, and how you could face your fears and overcome them by the end of your law school life, because that would make you ready for whatever is coming up. So, yes, today's structure would be, we are going to discuss why mooting. We're going to start with that, and we are also going to end with that in order to make sure that we identify the arc that we have completed during the entirety of this lecture. Then we're going to talk a little bit about the types of moods that there exist. Then, how do you choose a mood, which is, in my opinion, probably the most important stage in doing any mood. It's the decision when you make that you're going to commit, may it be 3 months, 4 months, 6 months, 8 months, to a particular set of facts or a competition, and therefore this decision is absolutely important. Then we're going to discuss about how you should go about forming a team, what should be your responsibility division when you're working in a team, so how best you can get that chemistry going for you guys, and how to go about the research, which is something which I feel most of the law schools are unable to address, because we all understand that yes, we are habitual to giving examinations right from our prep classes and nurseries, but we are not really habitual to doing proper research in order to make some arguments, and going by it just in a very random manner is difficult, and it does not yield the best results. So it's important to research in a particular direction with a set structure which would help you get the best results possible. So it's ideally efficient researching. Then once you've done your research, how do you draft your memorial? Again, most of our law schools and most of the people you meet will not be able to tell you a lot about drafting a memorial because, well, it's an art in itself. And believe me when I say this, the ability to do research, the ability to draft memorial is going to help you in ways you cannot imagine, probably even 30 years from now, and well into your profession, be it that you're practicing as an advocate or you're practicing as a solicitor, or maybe even if you are probably working in a law firm in the corporate sector, but it is always going to help you out. Then we are going to understand what it takes to prepare well for the oral rounds, because that also is an entire process which commands certain special endeavors on your part. And then we are going to finally talk about some oral advocacy skills as to what makes you the best version of yourself when putting out any particular submission. So if we start with why mooting with the next slide, Ankush. So you would often see that uh, mooting has often been left only to the confines of adding CV value, so to say. So all of our friends, all of our seniors, most of them would say that, oh no, you should do this moot because this is going to add significant value to your CV or to your resume. Or maybe some would say that, you should do it for the laurels because, you get this much prize money, or you might get this kind of a brilliant award or something like that, which would help you become, the talk of the town for a little bit, so to say. But believe me, there is a lot more to it. There is an entire foundation to it, which most of the people are never able to realize. Trust me when I say this, if you're into mooting for only CV building, it will only get you that far. You will never be able to appreciate truly what this activity or this endeavor throughout your law school will get you, and you will probably never be able to reap its benefits. So, what you should do and what you should probably identify is that mooting helps you in ways such as, if you take it as an academic exercise, it's going to help you immensely. So be competitive. That's not my point. Definitely be competitive. But what is important is that you must understand that at the end of the day, there are certain takeaways from it which are not so tangible, which will add, some of it will add to your soft skills, while obviously some will add directly to your proper skills as well. But most of it will be your soft skills. How? So it would improve your analytical ability. And why do I say that? Is because when you're given a set of facts, when you're given a problem, a 10-page set of facts, what happens is that your brain starts functioning in a way that you start analyzing everything very minutely. So you are able to identify and appreciate the fine print, as they say, and that helps you improve your analytical ability. In addition to that, also your ability to think on your feet, that increases greatly. And the two biggest takeaways from any mooting endeavor, which I have felt for myself, and I'm sure a lot of good mooters would attest to, is that first of all, it helps you to draft or put down your thoughts and your arguments and submissions in a very succinct form. That is to say that mooting, maybe it might not get you a laurel, for example. It might not also add real value to your CV, but what it will do is it will allow you to put your thoughts, which maybe before the moot you were putting down in, say, 15 lines. After the moot, you'll be able to put that in 5 lines. And by the time you come to practice, after having done a few moots and after having spent a few years doing this entire thing again and again, you'll be able to put those exact thoughts in literally 2 lines. And that is a skill which would help you lifelong, be that you are an advocate or be that you even go on to become a judge or anyone for that matter. Legal field requires that your thoughts be as concise as possible. The second part it will help you to do is, apart from putting your thoughts down in a very methodical manner, it will allow you to also convey your thoughts through communication in a very effective manner. I believe most of our problems or most of our shortcomings can ideally be solved if we were effective communicators. And that is something which all of us, somewhere or the other, we lack at. Maybe it's talking to someone who's not from our jurisdiction and we are not able to, convey exactly what we mean, or someone who's, one of the primary languages does not involve English. So how do you convey yourself well? And apart from that, your ability to give out an argument different from the one that you have written to someone, say a judge in a particular case, or maybe an arbitrator in case of an arbitration, and to give that argument, that oral argument, which can bind the attention and appeal to the conscience of the adjudicator. That is the most important skill which I have felt which I have gained from mooting. I did a lot of moots, and interestingly, it is not a one night process. So a lot of you maybe, I mean, all of us, in fact, are very good at one thing or the other in our life. Maybe it is dancing, maybe it is singing, maybe it is a particular sport, or maybe it's something else. But if you go back and if you connect the dots backwards, you will find that you did not just become good at it overnight, right? So you had to put in the hours, you had to put in a lot of time into it and understand that yes, there is a certain set structure to it. You put in the hours, and then someday you'll start yielding the results in that manner. The same goes for mooting. If you expect that you've done one moot and it's going to completely change your life, it may not. It may, but it may also not. So, what I would recommend is that you do this sort of as an building capacity building exercise where you keep doing it again and again and again and again as much as you can, as long as you can. And the more you do it, the better you get at it, and the better all of these skills get over time. So by the end of your third or your fourth moot in your law school, or maybe even your fifth moot or whatever it is, you would be in a position where you will be able to identify, go through a judgment within seconds, a 100-page judgment within a minute, and you'll be able to identify many things which you did not know when you started law school. And these things will never be taught in a class because, ideally speaking, most of the law colleges and law schools, they focus on their set curriculum, which really doesn't involve mooting per se. So all of these skills, which will help you in practice and which will help you when you get into the field, are learned through these endeavors, such as mooting for that matter. Now, if we switch over to the next slide, which talks about the types of moots. So you broadly have two types, ideally national moots and international moots, if we are talking about simply in terms of participation of teams. Now, this is a misnomer in India, which I have seen of late, is that a lot of these moots which are based in international law use the term international moot. That is not correct. To be very frank with you, international moots are essentially moots which have some international participation, which have teams coming from the jurisdiction, other jurisdictions as well. In most of the national moots, you would have maybe problem based around constitution or any domestic law of India, and you only have participation from the domestic teams. As soon as you have participation from teams from other jurisdictions, then becomes an international moot in terms of participation. Also, you can differentiate between international and national moots based on the forum being involved, like I said. So, an international moot ideally would have an international forum because questions of international law don't really get settled in domestic courts across any of the countries because there are two countries involved. So, they can't just say that, okay, one country will say to the other that we'll have our dispute solved in your courts. That does not happen. So international law has its own forums, and you can have the ICJ, which is the International Court of Justice, or the ICC, which is the International Criminal Court, or you can have other various forums as well. Then, other than these two kinds of moots, the regular ones which we find, you have the arbitration moots, you have the WTO moots, which works on the World Trade Organization's dispute settlement understanding. You have your mock trial advocacies, which, in my opinion, are some of the best reflections of a real life advocacy, which you'll find because of the fact that you get to do cross examination in there. I'll get to it later in greater detail, but definitely, mock trial advocacy is very special and very unique in the sense that out of all the moves that you do, that one is probably one of the most realistic in the sense that your cross examination and your chief examination, which are again the backbone of any criminal trial, have to be done in a very meticulous manner. So, yes, there's a lot to learn from all of these moves, and all of them have certain variations of their own in terms of the procedures, or certain variations in terms of other practices involved, but largely they all have the similar structure where you have a case, as one party will take that case, the other party will contest the case, and there'll be an adjudicator or a judge to decide upon your case. That's it. That's the essence of it. Now, if we move to the next slide, uh, once you've identified that what are the types of moot, the question naturally falls is that how do you identify a moot which is perfect for you? Uh, Now, interestingly, you can do that in many ways. Sometimes it is important to identify that what is the history behind the mood, and that is, in my opinion, one of the most important things when you go out looking for the mood. Because before committing yourself over a period of 4 to 5 months, what's most important is that there are a lot of moods which are coming. Almost every law college is doing one of their own moods, or maybe doing multiple moods for that matter. Many organizations also do it. But what is key is that you understand that every mood has a certain history attached to it. So maybe some of you might have heard of a mood called the Jessup International Mood or the Willem C. Wiss International Mood. Now, all of these moods have a huge lineage behind them. So, Jessup, for example, has had around 50 odd editions. This has had about 20 odd editions. So, all of these have been in place for 20 years, 50 years. So, that is the reason why they are at the very top of the chain. Because over time, every year, these moods keep improving. And as they keep improving, the general level of it and the general quality of it also improves. So a mood which has been in place for a few years, which is getting good feedback from its participants from the past editions, is always likely to be one of the better moods which you can choose for. That is not to say that you should not go for a new mood. You should definitely go for it, but then these other factors are associated with it as well, such as what is the organization or the institution doing it. Now, there are certain institutions, I will not obviously take names here, but there are certain institutions which have been organizing big international rounds or national rounds of big international moods, and they're doing a terrible job at it. From getting judges who just are not briefed enough or who have not read the problem enough, or not being able to take care of even the minor inconveniences of the participants, that becomes a problem. And hence, it's very important to identify the institution or the organization which is organizing the moot. So, for example, if you have a moot which is being organized in arbitration by, say, MCIA for that matter, what you can be rest assured is MCIA, for those who don't know, is, by the way, Mumbai Center for International Arbitration. It's a well renowned international arbitration center which administers arbitration. Now, if they choose to do a moot and organize one, what you can be rest assured is that, okay, they will have certain quality attached to it by virtue of the fact that they will always have good arbitrators as the judges. So it will help you in a way that the quality of the entire round will also improve. Then the problem would be meticulously drafted as well because they'll take care of these things. So there is certain prestige associated with certain institutional organizations, and they largely have those kind of features. Then you should also identify what type of law is involved in that particular move. Now, for example, if I'm in my first year, first of all, I definitely would say that 100% go for any mood that you can, the best possible ones that you can. But for example, if I'm in my first year and if I'm asked to do a technical mood such as a mood on, say, space law, it will get a little bit tricky because in my first year, I am barely taught any legal subjects. That is not to say that you will ever be taught space law in your 5 years or 3 years at the law college. No, you will never be taught that. But what happens when you have studied maybe a few subjects of law, maybe a couple of years into your law school, you are able to understand and appreciate the law and the terminologies being used and the way things work and the way law works a little bit better. So, if you have been able to put in and learn a few subjects of law, then your choice of the mood, depending on the type of law, changes accordingly. Sometimes, and this is a very, very good factor to take into account, is if you really, really want to learn about an area of law. What happens is, by nature, most of us, having been students at some point in our life, or currently students in this case, uh, you would never ever take up the study of a special type of law during the time of your law school. What you would rather prefer is that you complete your subjects, you complete your classes for the day, go home, relax for a bit, and then come back the next day and just do the same thing. But what that does is that it starts to limit your ability to learn many things. And that has an adverse effect in the long run, because it's important to keep learning something new every day. So sometimes you can choose the mood on an area of law which you really want to learn. So, for example, if tomorrow I am not that aware of, say, international trade law, so what I should do is I should dive head first into doing a WTO moot. And what that would help me ideally is in understanding that, yes, now I understand the technicalities of trade law. I'm so sorry, there was just some disturbance, so I had to mute myself. I'm back again. So that is one another way of choosing it, that you identify something which really interests you or something which you want to learn genuinely, because your passion for that mood and your ability to work more in that mood will be very high. Now, another way of choosing it, and definitely you should account for it, is the mood problem itself. Now, most of the moods would release their problems first, and then they would, at least in India, would release their problems and then they would call for registrations. Certain international moods, you can easily identify that, okay, they will always be on the same point of law. For example, Willem C. Vis will always be on a question of arbitration or anything related to arbitration because it's an arbitration. Or Jessup would always be on international law. For example, ICC, Criminal Court, Moot Court Competition, will always be on international criminal law. So those are easy to identify, and you can preempt that yes, the problem will be on those lines. But for most of the national moods, once the problems are out, what you should ideally do is look at the problem, read the problem well so that you understand that, okay, uh, the problem is drafted in a way that it is clear that we have enough and sufficient information to make arguments based on this, and then go ahead with it. Because at times, and I'm sorry to say this, but a lot of moods that I have seen as well have had terrible problem drafting, absolutely terrible problem drafting, and that results in subpar arguments later on and even subpar judging later on, which doesn't really help you in the long run in terms of getting good skills out of it. Then one more thing which you should take into account is the location of the move. For example, if you are based out of say Mumbai and you want to, or the moot is being held in Assam, can you make sure that you are able to take care of that? Can you make arrange for the travel? If the institute is arranging for it, then that's great. Otherwise, you have to take that into account. If you're going for an international moot, and if the moot is in, say, Paris or something like that, then would you be able to take care of that? And also your monetary aspect, whether, would you be able to afford for the travel, or who's bearing the cost for the mood, etc. So all of these become very important and crucial factors when you make that decision. Now, over to the next slide. And once you have identified the right choice of mood, once you have made that decision that yes, you are going to devote the next 3 to 4 months for this particular mood, or maybe more, the question is that how do you make a team? Now, in making a team, there are again a few pointers which you should always be mindful of. So, things such as some colleges have their system of automatic allotment. That is to say, that colleges will have a ranking system based on an intra moot court, in which, say, the first rank person speaker would pair up with the second rank speaker and go for a moot, and the moot is allotted to them. If that happens, it's fine. But ideally, if that does not happen, then you should take the following things into account. And if you have the liberty of making your own team before even going for an intra move, then that will be the best. So this is how you go about it. What's most important in making any team, in not just mood but just about in general anywhere, is that you should be able to have a good working relationship with the person whom you are teaming up with. So in this particular case, if you have a friend who you know that yes, you have a very good understanding with, great. Even if you have an acquaintance, so that is to say not really a friend but someone who's your classmate or your fellow batchmate or a senior or a junior, but you have a very good understanding or a working relationship with him or her, then you should definitely go ahead and pair up with that person, because that is key in going ahead with any move, because it's a 5 to 6 month process, and you need to make sure that throughout those 5 to 6 months the understanding will always be in place. Because if you don't have that understanding in the beginning, it will not be a successful team. Then you should identify your strengths and try and find people who complement those strengths. So that is to say, if I know, for example, that I am a good researcher and that I am perfect for the role of a researcher, what I should be ideally looking for is a person who is a good speaker and someone who can put forth arguments in a good way, in a very assertive way. And all of you need to have the same objective in mind, and that is absolutely crucial. You can never have a person who has a different objective for the mood. That is to say, that their idea is that, oh, we just want to go there and just relax, go to a new city, explore the city, and I don't care about the mood. No, that can never happen. You must have the same objective in mind, which is to give your 100% for every endeavor that you undertake, and that's a given. Then you need some devoted people, because 5 months is not a short time and it's almost like a semester. So what you need is people who will stay devoted throughout. It cannot be that, okay, I'll work today and then I'll not work for a couple of days, but then I'm going to spend 8 hours on the next day. It never works. It will never work. So be careful of that. You need to have people who are going to be persistent, who are going to remain and stick along for the long time. And then you, is it necessary really to have like-minded people? That's a question which I get a lot. And my answer to that is absolutely no. The reason why I say this is, while having a like-minded person may be great because you both will think in the same direction and you are both likely to agree on most points, but having someone who has a different mindset or analyze, who can analyze the problem in a different tone, would help you in shaping up your arguments well, because that person may think from the other party's perspective really well, or that person may be able to identify an argument in a very different light than what you would have. And that is a very, very important thing to have in any team, because if all of you think in the same direction in this regard, there is very little space for creativity. So a person who thinks outside the box always brings a lot of creative solutions. So that's part of forming your team and what you should be mindful when you're picking your teammates. I think so. We need to have a break, as I've been told by the managing team. So let's break for maybe 5 minutes and then let's reconvene if that's all right. And then we'll take up. No problem at all.
Yes, yes. It's on, Ankush. Ankush, I cannot hear you. Yes, yes, yes. We'll be having a short break of 5 minutes right now, and I would request then all the participants to join in again with the same link after 5 minutes. Thank you. I once again welcome all the participants for being a part of this wonderful webinar, which is being held on Art of Mooting. Our esteemed speaker, Advocate Yashraj Samant sir, has provided us an insight on mooting skills. It has been a very interesting session as sir has briefed us about what is a moot, what are the types of moot, and how we can choose a moot that is perfect for us by seeing its history, the institution associated with it, and also the type of laws involved in the moot problem, and many more aspects. Sir has also talked about on how to form a team for these moot competitions. Now, without wasting any more time, I would love to hear you continue along with this session, sir. The floor is all yours, sir. Thank you.
Thank you again, Devina. Thank you again to the team for this wonderful session which is going on. I hope I'm not boring everyone to death with this because I am definitely looking forward to getting some questions. If anyone has so far on the things that we have discussed, especially in the context of how you make your team or how do you choose your mood or anything like that, or any questions in the first half of the lecture, then you will let me know. If the team can help me out with any questions which have come up so far, I'll be happy to take them right now, and then we can proceed with the rest of the lecture. Ankush, Devina, if anyone of you has any received any questions over here or on YouTube or wherever else it's being streamed.
If there are any questions, we'll let you know. We'll let you know, sir, soon.
Perfect, perfect. So
Yes,
let's
sir.
move ahead with discussing after we have identified how you make your team. You need to talk about how you are going to work about it. So it's ideally called responsibility division amongst the team members and how you should go about it. If I can ask Ankush to again please put up the slides and we can just discuss this ahead. I think one of the questions which I saw on YouTube was that what has been my experience with respect to my first moot. That's a very interesting question, and because I happen to be from the very first batch of Maharashtra National Law University, Mumbai, NLU Mumbai, my experience was very interesting, and I would definitely share that at the end of this lecture. So, whoever has asked that question, if you are keen to hear on it, definitely please do stay back till the end of it, and I'll be happy to share that experience with you. Anyway, now that we are back again, if I can ask Ankush to please switch over to the next slide after this one. After this one, I mean, sorry, yeah. Responsibility division. There you go. So now you have made your team, now you've identified your mood, and how do you go about it from there on? This is again the process which has to start at least a few months earlier. Now, all of these processes that I told you about, you cannot wait till the last minute to just work on a mood problem, or you cannot wait to just take things late when they come. You have to start them well in time, sometimes even before the problem is out if you have been allotted the mood. Sometimes you have to start well before even you're thinking of going for a move, because at times what you need to do is that you need to make sure that if there is a challenger, so to say, within your college of going for a moot, for example, if there's a moot called ABC and there is a challenger which has to take place, that means there will be multiple teams from the college competing against each other in order to get the opportunity to represent the college at that moot. If that's the case, then all of this has to start a few months in advance. That's the prerequisite, because you cannot leave everything to the last minute, and that will never end well if you do that. Anyway, so responsibility division. Now, first of all, you need to understand that in any move or team, there are ideally two kinds of individuals. You would have your speakers who are going to be the ones who are going to put forth the case, and you're going to have your researchers. A very, very big mistake that most people do, even while telling others about mooting, is that they tell you that all the research is reserved for the researcher. That never happens. But at the same time, you must also understand that the researcher is the most important cog in the wheel. Because without a researcher, you are like a ship in an ocean without the captain. That's what it usually is. Because a researcher's job will be to not only supplement both of the speakers when they argue or before they argue, but the researcher is the one who maintains knowledge of literally everything about the particular submission or about the particular field of law. And he has done the most extensive research and preparation in order to supplant the submissions being made by his speakers. And therefore, the researcher's job is so important. Usually, what happens is that you have some speakers who are there, and those speakers, they are too busy with their own arguments, and hence they lose track of the larger picture, which is to understand that okay, the judge wants to hear only certain things. Your argument might have certain things, but maybe the judge doesn't want to hear those and he wants to hear something else, because someone is in the current process of delivering that submission. He or she may not be able to get out of it and have an overview and understand what exactly the judge wants, or if the judge wants something else. That is where the researcher comes in. The researcher will be that person who will identify that, who will always take the pulse of the room and understand that okay, for now this submission makes more sense, so in this round you focus on this. And otherwise also, during the entire preparation and memorial making process, the researcher has a very crucial role of making sure that everything is in order. That is not to say that you leave everything on the researcher, that okay, you do it, we are only going to argue. No, we are not senior advocates yet, those who work on a brief. So we have to do our part as well. So researcher takes care of everything. He is like the captain of the ship, like I said. Now, how do you go about dividing responsibilities amongst all of you? You do it through an issue based division. I have seen teams who go through a very odd kind of a division, which is to say that they say, I'm going to deal for this issue from the applicant side or the petitioner side, and my other speaker is going to deal with the same issue but on the respondent side. No, that doesn't work. How you should ideally do is, so every problem, every moot problem has to have some issues involved in it. Those issues are ideally questions of law, or in trial advocacy, question of facts, which must be addressed and put forth to the court on what your submissions will be. So it could be two, it could be three, it could be more, it could be even five or six or seven. What you should ideally do is that you should divide your responsibility issue wise. That is to say that, for example, if I am doing a moot and alongside me there is a friend of mine who's a speaker as well, and then there's a third researcher, we should identify and say that, okay, issue 1 and 2, say, which deal with maintainability and the constitutionality of the rules, they will be under me. And then issue 3 and 4, which deal with the other rules, will be with my other speaker. And the researcher will also help us both in both of these issues. That's how usually it will be. Now, what happens is sometimes when you do this kind of an issue division, you can be landing in a difficult spot. That is to say that you might be in a situation where uh, you have got your issue and you are so engrossed with your issue that you have lost track completely of what the other person is doing, or what your other speaker is doing, or what his issue is all about. So that is why I say we've always heard the term jack of all trades, master of none, but I've tweaked it. I call it jack of all trades and master of some. That is to say that not only should you master your own issue, that is master of some, but you should also know each and everything about every other issue in your submission. Because from the point of view of a judge who's sitting there asking you questions, I would usually ask questions whichever I feel are right in that moment. And maybe those questions might not exactly pertain to your issue. And if that's the case, if these questions do not really pertain to the issue that you are addressing, your answer should not always be that my co counsel is going to deal with it, Your Lordship. No, it cannot be. Instead, what you should do is give the judge an answer there and then, maybe a short two-liner to satisfy the query there, and then let them know that this is the answer to your query, a one-liner, and in detail, my co-counsel is addressing this in his submissions. So what happens, that gives us as a judge a very good impression that the team is not only well prepared on their issue, that every speaker is well prepared on their issue, but the speakers are also aware of the entire problem. And therefore, when you divide work, when you divide issues as well, what is absolutely important is that you have thorough discussions on all the issues together, the researcher and the speakers, all of them. You must make sure that at all times you are discussing it in a way that everyone is aware of almost everything. Obviously, the research of it, the good chunk of it, may be undertaken by one speaker on his or her particular issue, but the discussion on it, and after discussion when you are drafting it and after you've drafted it, it must also be understood by everyone who's part of the team, even if that person doesn't really have an active role to play. So always make sure that you do that, understand each and every issue in detail, no matter which one you are addressing. Now, after this, there's something to be worked out, which is, I call it establishing a workflow, which ideally means that you should identify the best and the most efficient manner in which you guys will communicate, and the best and the most efficient manner in which you guys will share your files, or you guys are going to go about reading documents, and etc. etc. Because most of the time will otherwise be spent into just searching for a document, or maybe you might just spend a lot of time in just getting that updated file across to the other person. Brilliantly. There are other things. What is key is that you identify that in the realm of technology, what is efficient for you. Some make a common WhatsApp group, some make a common email ID or Google group, or etc. etc. Whatever works well for you, go ahead with it. Uh, then fundamental reading, and this is again pertaining to my point that everyone should know everything, is that before you start drafting your memorial and before you even start researching, you must always be aware of and have read in detail everything fundamental about that particular area of law. So, for example, if you're doing a moot which pertains to uh, environmental law. Now, your duty should be that you make sure that before even the problem comes out, you have read almost everything related to environmental law, whether it is in the international context or in the domestic jurisdiction. So make sure that you do it. By everything, I mean read a couple of the most prominent commentaries on environmental law pertaining to that jurisdiction. Read all the particular legislations relating to that area of law. And also, you must be aware of how the system or the judgments in that area work. That is to say, that uh, for example, is there a judgment of the NGT which is very important in this area, or is there a judgment of compat which is very, or an order of compat in this area? And you must identify that and read that, all of you, all members of the team, without fail, before you go ahead with researching. Which brings me to my next slide, Ankush. If you can just move, please. So, how to research? Now, the first and the most fundamental rule, I call it the rule of 20. That is, that you must read the problem at least 20 times as soon as it is out. So, what it means is that you don't have to just mindlessly ramble upon and read it just for the sake of meeting that 20 number threshold. What it ideally is, and I'm a firm believer in this, that we lose the mood 99% of the time, or we perform below our expectations 99% of the time, because we did not read the fact sheet or the proposition or the problem correctly or enough times. That's the thing. Believe me when I say this. I'll just mute for a minute, please. I just, there's some disturbance. Yes, thank you so much for that. So, the rule of 20 is ideally based in this idea that every time you read the problem, there will be a new fact which comes up, which is going to alter your argument completely. Or at least it's going to give you a very, very good ground to make your further arguments, because most of the problems are made in that way. And it's the fine things that we miss out on the first reading. And then on the second reading, we might identify a few more things. And it keeps on going like that. So believe me, till the day of your actual mood itself, you need to read the problem every day. And in the first instance, as soon as it is out, you should read it at least 20 times to even be close to where you want to be in giving your best for the mood. And those 20 should be meaningful 20. It can't just be that I'm reading it just for the sake of doing it. Read it by putting in all the efforts that are required of that mood, by putting in uh, proper care and diligence. Highlight it if that helps you, or if that doesn't help you, then you may at least mark out a few things here and there. Make a list of dates if that's important, because everything becomes clearer like that. So do it. Then, with respect to research, sadly now most of our research would have to be online, given that we don't have access to a lot of books right now. But a familiarity with online law databases is a must. So the sooner you are able to learn Manupatra, SCC Online, Westlaw, Kluwer, which is an arbitration-based research engine, you need to understand that yes, all of them work slightly differently, but at the core they are doing the same thing. You search by keyword, some orders, some judgments, something some authoritative text comes up, and there you have it. So always be mindful of that, and always make sure that you are able to understand how to utilize any law database to the full efficiency. Then the importance of keywords, and I can't stress this enough. Now, for example, I have to search on a problem which pertains to breach of a contract by way of non-payment of dues, right? It's a very common understanding. So while doing an online search, my search in the search engine cannot say breach of a contract when there is non-payment of dues, what is it known as, or something like that. No, these words are not really helpful. The keywords are helpful. So breach is helpful, so non-payment or non-performance would be helpful, dues would be helpful, and all of these words are crucial. And therefore everything that you search about would depend on the keywords that you're using to make that search, because Google is based on, or any other search engine is also based on same principle, that keywords certain keywords have higher priority compared to the other keywords. And all the articles that you're looking for would have certain keywords which are absolutely important for you to note down and make sure that you are searching it that way. Then we are following it up with the authoritative texts. And why do I say that authoritative texts only is because in an argument, if you tell the judge that and if the judge asks for what is the authority on this, you can never say that, oh, I know this, or I just know this because my professor told me so. No, that's not an argument. I'm sorry. Because unless your professor happens to be the greatest jurist in the world, still people would not really care about that. What you have to ideally do is that you have to make sure that you are giving a good judgment or a good recognized and internationally acclaimed author's viewpoint on that, because that is what is accepted. Books are your best friend, and I can't stress this enough. Commentaries and digests and other aspects on particular laws or otherwise also, they are the real guiding force behind making any argument, because they are authoritative texts in themselves, and also they give you a good direction as to what is going on around that particular subject area. So make sure that you utilize the books to the best of your advantage. Don't just make your entire research online, because that is not going to help you a lot. So make sure you hit the library, that you use the library, your college library, to the best effect possible. Now, timelines and schedules. Again, a very important thing. At the outset, when you are starting your research, make sure you have a timetable set in front of you. That is to say that you must identify that, for example, 1 week from today, I would have done with all my research in terms of getting all the articles and all the particular books on this subject matter. Then, in 2 weeks from there on, I would have read all the particular texts and matters and collected some material for my arguments. So, this is the kind of timeline and schedule that you need to follow, and you need to stick to it. So, don't miss your deadlines, although it's you who's setting it, but never ever miss it as a team. And you can't procrastinate. And I am pretty sure that every one of us, including myself, we are habitual to this, because, well, procrastination just comes naturally to humans, to most of us actually. What we do is we tend to put it off till the last minute. So if there is, maybe we know that, okay, there is only one topic which we need to read from this book, we will never give it the due importance. We will say that, all right, I'll read it, maybe not today, tomorrow, or something came up, so I'll read it maybe in 3 days' time, and that day will never come. So never procrastinate. Read it there and then, whenever possible, or at the earliest instance possible. Because the moment you procrastinate, you're likely to miss out on a brilliant piece of research which could have otherwise solved all your problems going ahead in that argument. So that's very key. Don't do that. Now you have your research in place, you've got all the books ready, you've got all the articles ready, you have the judgments, you know what the law is about. So how do you start about drafting your memorial? And that's the next part of my presentation. If Ankush, you can just push it to the next slide. So drafting a memorial, the first question you may ask is, what is the right time to draft a memorial? The answer to that is, there is no right time. Every minute is a right time in that regard, because memorial cannot be made in one night. Although, yes, I would be lying if I say so that I have not been guilty of that. I have done it in the past, and believe me, it's not something which I would recommend ever. It can be made in a short duration as well, but the quality will not even be an iota of what you can actually deliver on. So, what is important is that you do it in process, in phases, that is to say. So, you start off early, you get your things which annoy you a lot out of the way. So, for example, usually everything has a statement of jurisdiction. Get that out of the way. It's easy to make. Get it out of the way. Your prayer is pretty much set in stone. You're not going to ask any other relief than that mentioned in the fact sheet. Get that out of the way. Prepare it. Get the template ready. By template, I mean you get some things ready. So, all of these, once you get it out of the way, statement of facts, which is just a summary of the entire fact sheet. So, get that out of the way. uh, get those done early, because these are mechanical processes. And when you need to start drafting, what you need to do is, during a research period itself, you identify the lines which are important. In, say, a judgment, you find something which is very important, the ratio is important. you make sure you have a document ready in which you have pasted that ratio, you pasted the name of the judgment, and then you will refer to it. Now, a facts based structure, what I mean by that is before you start with all your legal arguments, because that's human nature, what we do is we get ahead of ourselves. As young people, we are rather impatient. We don't have the patience required to, wait and go by a process. What we do is we ideally identify that, oh, this is the law applicable to this particular fact, and this is the argument. So you need to hold your horses. Start with a factual argument or a fact structure first, which is to say, go through the entire problem, make a skeleton based simply on facts. So once you have the facts, and then when you research the law, you'll always have that fact based structure in your mind. So you will automatically start putting your pointers with related to, say, you found something on the first part of your issue. You would automatically take that bit and put it in the first part of your issue, and there you have some back into your law. And how do you go about writing an argument is this rule called the IRAC rule. Now, maybe some of you might know or some of you might not know. Irrespective of that, this is the fundamental rule which will help you not just here, but in absolutely everything that you're going about. If you start writing your even your answers in your examinations in the IRAC rule form, trust me, your professor and your teacher, as long as the content is right, will always be able to mark you very high, because IRAC rule means that you are very clear. You've made it into almost like a formula of sorts of making your submission. So it looks very neat, it looks very clear, it's cogent, it's very, very, very identifiable at the outset. So what it is that I stands for issue, R stands for rule, A stands for analysis, and C stands for conclusion. So what it means is that you have a given issue, which is pretty clear. So for example, we go back again to our initial example, which is that whether there is a breach of contract on account of non-payment of dues. So that is the issue for me. Now the rule says that you identify what is the law surrounding it. So the law surrounding that would be, there will be a twofold law. The first would be the Indian Contract Act, and the second would be the contract term itself, whatever the terms of the contract are. So the rule part involves that you mention what the actual law as it stands is. So if it means that yes, when there is a certain non-performance of any due, and if it is not specifically mentioned in the contract, then yes, it will be termed a breach. And the rule also would include certain other things, whereas the contract itself is valid, and whether the claim for dues is valid. Your analysis or your application part is when you apply that rule to the set of facts. So if my fact says that A completed some work and B was supposed to pay A, but B did not pay A in time. So if, say, B was supposed to make the payment for the work done in 10 days, he did not do it and it's been a month. Now, my application would be that if a person fails to pay the money in so and so and so and so time, then that person is liable. That might be the standing law. So I take this law, I apply it to my facts, and therefore I come to the last part, which is the conclusion. So in the conclusion, you come to this, you identify it, what is the result after applying the given law to your set of facts, and you have your conclusion. But don't just leave it at that. You also have to always give a nice rounding off to your conclusion. So a short summary in a couple of lines will always help. So the entire issue, you need to do that, and you have to follow this in literally every paragraph. So every assertion that you make or every argument that you make, IRAC is the rule that you have to follow. There is a variation to IRAC called FIRAC or FIRAC. What it ideally means is that the F stands for facts. So you start with the facts, then you give the problem, the issue, the question of law, then you give the rule, that is the existing law, and then you start with the analysis and the conclusion. I believe personally that FIRAC is definitely a little bit better in terms of giving some clarity to your content. But at the same time, if you are able to make your facts abundantly clear at the outset in a different paragraph or in a common paragraph before you start the issue or a sub argument, then that would work as well, because that would ideally mean that you're following FIRAC somewhere at some stage. So it works very well. Now, there are three C's I tell you to drafting, which will always help you. So, always be mindful of it. Your structure and your arguments should always be, they should be cogent. And all these three things are absolutely important. Unless you are able to convey in those many words what you want to convey, the reader will never get the idea, and you are likely to be marked pretty low on your memorandum, and also in your submissions it might be a problem. Similarly, it has to be concise. Nobody likes to read something which can be said in 2 lines, and they do not like reading 5 pages on it, or maybe 2 pages on it. Nobody likes that. And it has to be cogent. That means it has to appeal to that conscience. It has to be clear in terms of its application of law, etc., the assertion. So it has to be like that, very, very clear. And now refining. So always make sure that you refine whatever it is that you're writing. Refine is the rule, is the name of the game. The more you do it, the better your memorandum will look. So don't leave the first draft of your memorandum till the last night of submission. You better make it at least a few weeks in advance so that you have enough time to refine it. Maybe ask your moot coach, or maybe ask your faculty or your seniors or experienced mooters to go through it once, get their inputs on it, and get it as refined, as crisp as possible. A shorter memo never hurts. In fact, that is one of the best memos if it is clear enough. Now, formatting is, in my opinion, the most important thing, one of the most important thing, and yet one of the most overlooked thing. Because what we believe in is that, all right, formatting, nobody cares, everybody cares about the content. But to be very, very honest with you, at least in most national moot courts, and I'm not giving a generalized statement, but in most of the ones that I have been a part of or I've seen, formatting appeals to your subconscious, and things which appeal to your subconscious inadvertently impact your final decision. So if you have a well formatted memo, it will always give a very good impression of a confident drafter, of a confident team in general. So when you have a good formatted moot court memo, it helps give a good impression, and also it makes it more legible to the reader, that which in this case will also be your evaluator or your assessor. So it's important. Then you need to identify that how you're going to use Microsoft Word to its full potential. For Apple Mac users, there is also something called Pages, but it's not that great, to be very honest, compared to Microsoft Word, especially when it comes to using certain tools. So, giving footnotes, giving references, that auto generating table of contents, auto generating the table of citations is something which is very, very important and comes in very handy in Microsoft Word. So, get to it, do it, learn it if you have to, because it will come in very, very handy. Which brings me to, now that you have your memo ready, everything is in place, which comes and brings me to your preparation for the oral rounds. So if we just switch over to the next slide, please. Thank you. So preparing for the oral rounds. Now, the most important part in this regard is that you need to time your arguments very, very well. By that, I mean, what biggest error that we do is we time ourselves as per that it's going to be a monologue through and through. It will never be a monologue. You have to identify and give space for some questions from the bench as well, because the bench is going to ask you a few questions which are going to impact the entire argument itself. So your argument will change its structure. It will be a dynamic structure, so to say, depending on the questions which are flowing in. But what we need to do is make sure that we are able to accommodate answering those questions and making most of our submissions. You'll never be able to make all of your submissions. So making most of it. A structure, by that I mean the most logically coherent structure. Even if it deviates a little from your memorandum, that's fine. It does not matter. But always make sure that you have a basic structure in place which will help you to identify that, okay, this is the direction in which I want to take my argument on this issue, and that is what it will be. Pick and choose. So always make sure that you are picking and choosing your best arguments only. Trust me, during the entirety of a round, you would be able to make only 2 submissions at best in a given issue, if there are some questions flowing in from the bench. And if there are a lot of questions, you may only be able to make 1 submission per se. So you have to make sure that you give your best argument up front, because that would be your most impactful and the best argument upfront, which will give the best impression. That happens in real life too. In fact, coincidentally, one of the matters that I was working with, there might have been a number of submissions which we had, a number of grounds which we had, but you get literally 2 minutes in real life in a court to, during admission time or during etc. And those 2 minutes here, you can only give one submission ID, and that's it. So make sure that it's the best submission that you can put forward. And I can't stress this enough again. Practice, practice, practice. Nothing beats practice. Nothing beats a person who has practiced it 1,000 different times. So go for it. Make sure that you are practicing your arguments as much as you can. Give yourself ample time before the oral rounds and preempt the questions. By that I mean that once you have read enough, once you have read a lot about that particular area of law, you will start thinking like a judge would, ideally. That should be your target. And once you start thinking like a judge, the questions will follow very, very swiftly. So you yourself will be able to identify, okay, this is my argument. I know for a fact that this would be one of the questions that the judge might ask. So if you have that question in place, you can easily identify 20 other questions, and before you know it, you would be ready with the answers to these questions before the judge even asks. So at the time of the rounds, this will help you immensely. And finally, you have to have a different understanding, a different demeanor, and a way of delivery, depending on which forum you're arguing in front of. So, in national moods based out of Indian courts, high courts, or the Supreme Court, the general nature, which I have also seen across the judges, is you can be a little aggressive. I wouldn't say a lot, but a little aggressive. Or you could also maybe be a little used to, because they are used to ideally practices from the court. So they are set in that structure now. So you can maybe take some liberties which you cannot in an international forum. Because in an international forum, you have to speak slowly. You have to be clear with your words. And at the same time, you have to be humble yet assertive. That holds true, in fact, even for national rounds. Even if you're not aggressive, that's fine. What is important is that you should always be assertive, because being assertive beats everything else. So your one submission should be enough to appeal to the conscience of the judge without having to shout at the top of your voice, because it is so well reasoned, because it's so well drafted, and it's so well conveyed. That's the idea. And finally, over to some oral advocacy skills. Now, these are skills which will help you not just now, but even going ahead in time. If you switch to the next slide, please, Ankush. And this also happens to be my last slide for the day. So, oral advocacy skills. And these are your best takeaways which you will have from a moot court. And believe me, none of these are things which you can put on your CV. You can have a look at it as much. You can pause the video and look at it. None of this is something which you are likely to put on your CV, because you can't. But all of these are absolutely crucial in your success as a legal professional later in your career. So you got to think in English. The reason I say this is that most of the moot courts, they have English as the primary language. Most of the court proceedings in most high courts and Supreme Court, etc., are also in English. So thinking in English helps you to reduce one crucial step. Otherwise, what would happen is you're likely to read in English, your mind would translate it to Hindi, you would understand it in Hindi, then you would convert it again in English in order to give your output or your submission. Now that's a four-step process which is pretty time consuming if you think about it, and in doing so you will lose a lot of the essence. Whereas if you start thinking in English, your delivery directly will be in English, and you don't have to go through the pains of converting it. Obviously, you are not converting it by saying it out loud or by writing it. It's a subconscious thing which happens. But even then, you start losing the actual effect that you would have if you were to think directly in that same language. So, thinking in English is the first part, which is going to help you even in your submissions later in court. The demeanor, that's the most important part. This is a problem across most mooters that I have seen, and in fact, most mooters that I've coached as well, is that getting the demeanor right is absolutely crucial, and most people do not understand it. Everybody says that you can be, you can be this, you can have some flair, and you can have some aggression to it, and always good to have aggression. I don't think so. Have a little aggression. That is to say, be loud, be confident. An aggression in a good sense, not an aggression that you're fighting with the judge or that you are being very, for the lack of a better word, over smart. So don't do that. The demeanor should always be that you are humble, that you respectfully bow down to the observations of the court in whatever they may say, but you are assertive enough to make sure that you get your point across and that you allow the judge to see what your argument contains and give him or her an opportunity to look at it and consider it positive. That should be your demeanor throughout. Doesn't matter if it's a national or an international moot court or in real life in the court. That is all that you require. Confidence, some assertiveness, and a great sense of humbleness or humility. So you need to be humble at all times, but at the same time, make sure that you are very clear in your submission. Now, court mannerisms are a big, big thing in the moot courts. They are again something which doesn't really affect directly per se, so you might not be able to identify it at the outset. But once you incorporate these things in your arguments, you'll understand that the judge himself or herself feels very at ease after having incorporated these things. So, court mannerisms such as whenever you are referring to the bench, sometimes they don't mind sir, but usually it is your lordship or your excellency or your honor in case of trial advocacy moves. So do that. Make sure you follow everything there is to court mannerisms. So you should be humble enough when they are asking a question. Don't uh, interrupt them. Let them ask the question. Say a little thank you or address the question with the greatest sense of respect. That is ideally what court mannerism is. So using the correct terms here and there, it helps. The posture and body language, now again, very important. I could be slouching like this, I could be slouching like this, but no, you should always be upright. You should be standing like this, and in case you're sitting down also in like an arbitration move, you should be sitting down like this, so that there is a sense of confidence which emanates from your body language. Because believe me, 90% of your communication is not through words but through your eyes and through your body language. So having a positive, confident body language, a good posture is always helpful. Thinking before you speak, again, can't stress this enough. You must always be mindful of what you're saying, and you must always take into account uh, that what is it that the judge is asking, and are you even answering the question in that manner. So you should be mindful of that. Make sure you're addressing it in the best way possible. Think in English again, and use your pauses well. That is to say, you don't have to always rush. Sometimes let the argument dwell upon on the judge, because the judge is only hearing the argument probably for the first time. So you want that argument to also sink in. So maybe a pause of a couple of seconds here and there can make your argument that much more impactful. And even if it's not in the argument, sometimes even making a statement, if you take your pauses well, that statement is highlighted that much more by taking good pauses. Voice modulation is a must, something which requires that you need to stress on that a little bit more. You need to do that. When you're quoting from a judgment directly, you need to have some modulation to it. So make sure that you do that. All of these are tips which are also going to help you in your real life advocacy when you go ahead. Answering a question. So, again, like I said earlier, make sure that you answer exactly what is asked. If the judge asks you that, is this a case of murder? Obviously, it's a difficult question to ask. No judge is going to ask you that. But if you are in that kind of a situation where you've already been convicted of murder or something like that, make sure that you're giving a yes or a no question in the first place. So if the judge asks you, for example, a better example would be that, did the terms of the contract ever specify a schedule by when the payment was to be made? So don't beat around the bush and say, my lord, that it is difficult to ascertain that from the terms of the contract. No. The first word should always answer the question of the judge, which is no. However, my lord, the terms also had a negotiation history behind them, and therefore that is also relevant. The moment you make that, the judge understands that yes, you have A, answered the question, and B, you have made yourself abundantly clear that there is something else to it as well. And finally, one thing which I get a lot is people ask me, should you replicate practicing advocates? So during your internships, you might work with an advocate. and you might go to the court and you'll see that okay, they have a certain way of going about it, and there are certain systems or ways of arguing which they utilize in court. And should you replicate them in a moot court? My answer would be no, but also yes. I'll try to explain. So no, as in the advocates in courts take a lot of liberties depending on their understanding or their standing in the court, or depending on their understanding with the judge, etc., on their seniority. So it's not always the best manner possible, because moot courts are a little more formalized in a way, and hearings that happen in court are a little more peculiar to that particular court. So it's different. It's comparing apples to oranges. And so you should be mindful that you don't copy them. However, what you should copy, or what you should always do, is their ability to put forth an argument beautifully. Most of the brilliant advocates of our times that you are seeing right now, they have this innate ability to put forth an argument in literally 3 lines or 4 lines in the best manner possible. They know what the judge wants to hear, and they're able to provide that. And that is a skill which I would say that all of you, without fail, should incorporate, whether or not you decide to go ahead in advocacy or not, because it's going to help you everywhere. And now that we have come to the end of it, as I'm also being told that we don't have a lot of time left, uh, so a couple of minutes to just sum it up. So all of these skills that I just talked about, and the researching and the drafting skills, are soft skills ideally, which will help you in life, even when you go ahead. So make sure that you utilize those to your advantage. These are fundamentally the same between practice and between moot courts. All you have to be mindful of is that you take into account that yes, things are different when you go into the field. When you are there in a court, standing in a court, things are not going to be like this, because there's very little time like that. But also fundamentally is going to be the same. So your ability to get 2 minutes of the best particular of your argument or your submission forth, putting that forth, or ability to answer the judge effectively, all of that remains the same. So I guess that sums it up. Thank you so much, everybody, for tuning in. I think there are a few questions which have flown, but due to paucity of time, if Ankush may let me know if we can take the questions now or after a break, Ankush. Sure. So we'll take a, if you can just copy these questions, because I'm not sure if the chat is going to remain saved. So if you can just copy these questions, and then I'll be happy to take the questions. And then I know I am keeping you from lunch, so I won't take that much time. We'll see you all in like 5 minutes. Thank you.
We'll be having a 5 minutes break. Oh, yes, yes, sure. Yes. We'll be having a 5 minutes. We'll be having a 5 minutes break, and after that, we'll be dealing with some questions. We'll be having a question and answer round, and then that will be the end of the session. So I kindly request everyone to join in after with the same link after 5 minutes. Thank Yes, yes, yes. Yes. I once again welcome all the participants. Now we'll be having a question answer round. So, sir, if we can start the question answer round.
Absolutely, I'll be happy to do that. I think the previous chat got lost, so if anyone has any questions, they may put it up right now. If the organizers have copied it,
Yes, sir, we have noted the questions.
wonderful. So
So
if
the
you can just
first
paste it here,
question,
I'll just take that up. Oh, you want to?
yes,
Yeah,
sir,
you can
okay,
just
sir.
tell me. You can tell me. No problem.
So the first question is that if we don't have a good team, does that mean we should not participate at all?
Uh, no, definitely that is not what I meant to say when I said that you should have a good team or not. What is important is that every team can be a good team. See, there is no preconceived idea of there is a good team or a bad team. What matters is that you are able to make sure that your team has a great team chemistry and that all of you are able to put in the effort. So, for example, someone asked me what was my first experience with the Moot. Uh, it's very interesting. So, my first experience with the Moot was the NLU J antitrust Moot, which is NLU Jodhpur's antitrust Moot. This was in my second semester, where the only legal subjects that we had read till then was one subject on legal methods, one on torts, and one which we are just studying then on contracts. Now, for these three things to do an antitrust moot in your second semester is a completely difficult deal altogether. But even then, what made sure that we were able to put in that effort was just two things: that I had very good teammates, that we could count on each other, that even though all of us were of the same semester, that we didn't have anyone to guide us as such. And we definitely did not have a good library at the time because it was only 2 semesters that the university had been in existence, barely 6 months. But what changed for us was that all of us were working very well with each other together. So we could understand that yes, this is what the need of this particular moot is, this is what we should be researching on, and this is how we should go about it. So once you do that, even if your team you feel that you are not as strong as you could have been, it does not matter. It absolutely does not matter because your takeaways from the moot should not only be that only a win or nothing else. The takeaways will be very, very different. Takeaways will be things which you'll understand 4 years later. So, yeah, definitely do not back down from the move depending on just your team alone.
Thank you so much, sir. The second question is that should we learn arguments? Should we memorize everything what's there in our issues?
So, yes, you should know everything in your issues. Ideally, the best sort of submissions, oral submissions that you're going to make is when you don't even have to refer to your submissions, right? That would be the best form of submissions. Having said that, you will never be able to make all of them, but you should know all of them because in some form or the other, if there is a good question which has come up, you should be able to incorporate your argument in one of the answers to the question from the judge. So knowing your memo inside out, knowing your submissions inside out is a sine qua non, which means it's an absolute necessity. At the same time, when you are arguing or when you're giving your submissions, you don't have to just you know literally reiterate what has been written or go by a set structure that you have absolutely rote learned something. No, it shouldn't be that way. Be fluid, be flexible, and understand the situation. Accordingly, shape up your argument as you go along because you'll never be able to make your argument at the outset as you had planned. I hope that answers the question.
Thank you so much, sir. So the third question is that how to have the edge over the other teams?
How to have the edge over the other teams? Very good question in a way that yes, we all are very competitive in a sense, but always remember that your competition should only be with your own self. If you can battle that one little thing which has always been difficult for you to address in all your time, if you can overcome that, then you're already, that moot is a success for you. For example, like I said earlier, if I have a fear of public speaking, my intention to go into a moot can only or should only ideally be that yes, I am going to address my fear of public speaking, and at the end of the mood, I am going to be out of this and I'm going to be better. That I am going to face my fears and overcome them. That should be your idea. But how to have an edge over the other teams, particularly if you're talking about it, make sure that you put in the hours. One thing which I've always followed is you need to be the most well researched person in the room. Learn everything about the law that there exists. Knowledge trumps everything else. If you have knowledge, you know when and where to use it. So make sure you do that. Be well researched, be thorough, and be clear. You do that, that's fine then. I guess that answers.
So much, sir. The other question is that organizers of the competition draft the problem in such a way that it is equally balanced from both the sides. But sometimes when we read the proposition, it favors only one party. What should we
Right.
do in such kind of situation, sir?
Uh, Interestingly, this is something which has happened in almost all of my books. What happens is you start with a problem, you think about a problem, and then you're going ahead with it, you read it, you feel that, oh, this problem is all petitioner based. And by the end of your entire memorial which you have made, you find out that you have researched so extensively for the respondent, and you have done so well that the respondent side has become stronger in a way. So going just by the problem, you don't have to think about it too much, because inadvertently you will find authorities on both the sides. And wherever law fails you, logic will never fail you. So that is to say, if you can't find something by law, get a logical conclusion or an answer to it, and then you supplant it with some law, whatever is existing. So make sure that you are always understanding that even if a problem might at the outset seem tilted towards one side, it really is not. When you go about researching things, it depends on your efforts that you put into the research. If you're able to make a good argument, doesn't matter if you don't have a lot of authorities, if that argument appeals to the judge, that argument will be respected and accepted. So if a problem is tilting in one direction, that's nothing to worry about. That is always the case. There will be some overwhelming evidence, but that does not mean that the other side does not have a chance at all. In fact, if anything, that should be uh, almost like uh, an encouraging thing for you to do some more research in that area, to make sure that you defend that side so well, even against all the factual situations, against everything being against this particular side. So yeah.
Much, sir. We have another question. How to tackle a question which is not related to the given proposition, sir?
So ideally, any question which follows, which is not related to the given proposition, if it's a question on law, ideally it is going to be a question which is related to that particular field of law. It's not as if a question will be from a completely different field of law. So you should have read that by then, because that is what your research is. You should not just read only thing about that particular law. For example, in the Constitution, if I'm only concerned with 32, if my particular matter is a 32, Article 32, doesn't mean that I just don't read anything about the jurisdiction of the high courts in the writ petition, because they are allied fields at the end of the day. So make sure that you read those as well. But having said that, if by chance there is something which you don't know, so there are two ways of going about it. One is that you use some logic to it and hope that it is correct in that manner, or the other is that you may apologize from to the judge, that you may say that, my lords, I am afraid that at the moment I may not be able to address your query, but if you give me time, by the end of my arguments, my research team will have this ready and we'll make a submission on this. So this is something which happens also in courts. So if the judge asks something, so the lawyers might say that we'll get this to you by by the end of the matter or by the end of the board or something like that. It's a similar understanding there. So never say directly that that I apologize that I don't know the answer to this. No, that doesn't help. Show something that yes, you are willing to look for it even though you do not know it. That is respected more than a blatant word, or an absolute apology, or the refusal to answer. And if it's a fact-based thing, then you may very, very gently and politely say that, my lord, uh, while I'll be happy to answer that, but it will be only a conjecture at this point, since the fact sheet is silent on this. That's a very safe answer if they are asking with respect to a fact which doesn't really exist. So yeah, I hope that answers.
So we have more two questions. Uh,
Right.
so if you could suggest some more website which would be helpful in the virtual moot court competitions, as there is no library access during this lockdown.
Uh, I'm afraid there are not really that many websites which will help you in terms of uh, in virtual moot court. I didn't really understand what the question is. The person can follow it up, but I'm if I understand from whatever the question is, when they say that virtual moot court, there are not a lot of websites. I guess they are referring to the information being available online. Yes, there are not a lot of good websites which might guide you in this regard, but even then, your basic search engines like SCC, Manupatra, etc., will give you at least the cases. And then, if you are able to utilize the online search engines by using the correct keywords, you will find a lot of good articles, authoritative texts. Obviously, for the books right now, it's difficult as there is no library access. But then again, it is not just you, it will be the case for near about everyone else as well, because the colleges are closed down in a way. You can't access libraries, so you don't have to be so worried about that. In a few months time, things will be better, we are back to normal, so you don't have to worry. With respect to international moods, if you are doing any, they always have reference to sources online, right? So you don't have to worry about that. Some of the international moods also have their own websites, which have been running for quite a few years. For example, again, Willem Sevis has their own, Stetson has their own. So all of these moods, they have their own websites with some knowledge base there to help with some quick reference of materials, and they may also have some further winning memorials from past editions, which is also important to have a look at to get an idea as to what are the authoritative texts in this field. It's a good starting point also if you want to search in that area. I hope that answers the question.
Yes, sir. And the last question is that, sir, if you could enlighten us on the points which shall be used at the time of the rebuttal, which makes the rebuttal very important at the time of the conclusion.
So, interestingly, rebuttals are 99% of the time not really marked. Okay, that is something which is very common across moot courts. However, that doesn't mean that you should not give your best in a rebuttal, because it is at the end of the day a last word on whatever it is. So the first rule of rebuttal is that your rebuttal can't really be outside what the other party has really said, because you're rebutting something. That means there has to be a submission in the first place which you are rebutting. Now, problem is, as a respondent, you have ample opportunities to address the arguments of the claimant or the applicant or the petitioner in the course of your own arguments, because you've already heard them. So it's easier. So you only get a chance as respondent to do a sur rebuttal. The petitioner on the other side, once they hear the respondent's argument, can make a rebuttal. What I would say for rebuttal is usually reserve only a minute for rebuttal, never more. A minute is absolute tops. Maybe you take minute and a half. That's it. But in that rebuttal, make sure that you only cover one or at best 2 points. And always pick the 2 points which support your cause the best. Don't try to find fault in the submission of the respondent. The reason being because judges most often will not remember it till that point, that what the respondent had said on a particular point. Don't pick them up on if there is a particular word which they got wrong or a wrong usage of the word. Rather, identify points which or arguments which they made and which you have the strongest possible argument to, right? So your strongest suit will always give you confidence in making that argument. So do that. That will make your rebuttal that much more effective.
Thank you so much, sir. You all the questions have been done. Thank you so much, sir, for answering all these questions.
It's my pleasure, Devina. Thank you so much to you, to Ankush, to the entire organizing team, and especially thanks to the principal, Mr. Singh, and your Court Association, Mr. Rao, Ms. Kadri, and everyone else who was kind enough to invite me. And it's been a wonderful, wonderful time that I had with you all. I am sure that even if it's on YouTube, it will be seen later on. If someone likes it, then that's wonderful. If you find it helpful, in any case whatsoever, always remember that no matter what you do in a moot, your takeaways will be far different than what you realize right now. So your takeaways will always be the soft skill which will improve you later and which will keep you in, in the correct with a person with a great acumen all throughout your legal career. So do it for that. Do a moot for that. And that should be your only takeaway. So don't be dejected if you don't get a particular place in the moot court. Doesn't matter. At the end of a moot court, have realistic expectations that yes, we want to win, no doubt, everybody wants to win, but have expectations that at the end of say this moot, I would have known the law involved in this field completely. So tomorrow, if anyone asks me anything on this law, I will never be black, which otherwise I would have been if I would have not done this. The moment you change that mindset, the moment you change the terms of the competition, so to say, competition is a success for you. So don't worry, keep at it. It's a process, it's not an overnight thing, and perseverance always pays off. Hard work always pays off. So do that. I think with that, I hand it over back to Devina. Thank you so much, Devina. Over
Thank
to
you
you.
so much, sir, for such a wonderful session. I'm sure that all the participants have really learned a lot and will incorporate all these points, enhance their mooting skills, and also participate in many more moot competitions. On behalf of
Hey.
Thakur Ramnan, yes, sir, you can, yes,
No,
sir.
please go ahead. Please go ahead. Please go ahead.
On behalf of Thakur Ramnayan College of Law, I am grateful to have been given this opportunity to thank our guest speaker, Advocate Yashraj Samant sir, for such a wonderful session, interesting session. Thank you so much, sir, for taking out your valuable time and sharing with us your expertise. I would like to thank our beloved Principal Sir, Dr. A.K. Singh Sir, and also our teaching and non-teaching faculty members, including our Moot Court Association, for conducting such a productive session on a very important topic for developing all the students' mooting skills. Lastly, I would also like to thank our webinar team for making this webinar a very successful one. Once again, I thank all the participants for joining us today. Hope to see you all the next time and for the upcoming webinars. Thank you all and have a great day.
Thank you.